Good morning and welcome to Employment Hour in 30. If this is your first time catching the show, welcome aboard. Come on in. Water's warm. If it's a repeat and you're back for more, we got another amazing show for you this morning. If you're just joining us, I'm John Scholes. This is Lior Samfiru. I ask the questions. He answers all of them. Or most of them anyway.
Most of them.
Don't tell them that. They'll be fine. Contact anytime is help@employmentlawyer.ca, and of course there's employmenthourtv.ca as well. This is a show about your job, employment rights when it comes to severance, when it comes to being laid off, your boss, employers, employees. We cover all that on the show here. And we'll get to something amazing called the Severance Pay Calculator. This is the best, easiest, and quickest way on your laptop, on your desktop to find out exactly how much severance you should be getting. Lior created it. He built it. And by the way, this whole law thing doesn't work out, you should be building apps because this thing is phenomenal. We always start the show with, just to get warmed up, a few matters that have come across your desk. And so we'll get to it, man. What's happening?
Thanks, and I appreciate the career advice.
Yeah, you know.
Well, yeah, no, I'm glad to be back here to talk about workplace rights and employment law. A lot of people have watched this just recently for the first time, and they've been calling me in the office, giving me great feedback that they found it helpful. They learned new things.
Yep.
And that's the point. That's why we're here. If these things were obvious, if these things were known to everyone, we wouldn't need to be here to talk about them. But a lot of people have so many misconceptions and problems about workplace rights. You're watching us now probably on the weekend, and you're thinking, I had this bad week, my boss did or said something. What does that mean? And I'm worried about going back to work on Monday. Well, stay tuned. We'll talk about a lot of issues. And of course, if you want to talk to me privately, call me. Email me, we'll talk privately, we'll give you my contact information throughout the show. Now, to start off, let me tell you about a situation that came across my desk. I was contacted by a lady that had been off on a disability leave for about 3 years. She'd worked for the company for many years, about 15 total, but she was in a car accident, had to be off work, and was working hard to get better and get better. And even though she was in her 60s, she managed to get better, and finally was cleared to return to work on modified duties. In other words, her doctor said, you can go back to work, but your employer needs to help you. You need some help from your employer. Your job needs to change a bit so you can do it. And she was very happy and went to the employer, provided that note from the doctor, and said, I'm ready to come back to work finally after all these years, and here's my modified duties. The company's response was very quick, said, we don't have these duties for you, sorry. And essentially left her in limbo. Didn't fire her, didn't do anything, just left her in limbo. We can't help you. And she contacted me very upset, saying, well, what does that mean? And what's my status? Do they have to accommodate me? Do they have to help me? So here's the thing, John. First of all, let's start from the beginning. The fact that she was off on a disability leave, in this case about 3 years, does not change her employment status. She is still an employee. You can be off on a disability leave even for years. As long as there's a possibility of you coming back to work, you continue to be an employee. Now, in this case, because she was able to come back to work, her company is under a strict duty to accommodate her. Call this a duty to accommodate, and they have to accommodate even if it's difficult. It's not enough to say, oh gosh, that's pretty tough to do. We don't feel like it, it's too much. No. Even if it's difficult, a company has to accommodate your medical situation, your medical restrictions. That means maybe giving you different duties, different hours, flexibility, help, whatever it is. So this company's refusal to do this, not even looking into it, is a human rights violation. It's illegal. They have to provide that accommodation. And beyond that, that failure to bring her back is also a termination. They owe her severance, potentially as much as 2 years' pay just on the severance part alone. So this is a very important case, and I've spoken to so many people over the years where the employer does not accommodate them when they have these medical restrictions. So if that happens to you, understand that you have recourse. The law does come down hard on employers that don't accommodate. Not only would you potentially be entitled to damages for this failure to accommodate, but also severance. And for her, there's definitely going to be recourse.
And the doctor always has the trump card, especially if you're off. If the doctor says you're off, you stay off.
You stay off for as long as the doctor says so, and your employer has to comply with the restrictions imposed by your doctor. They can't really question those. So you have a doctor that's going to help you. That's very important. It can resolve a lot of workplace problems.
Help@employmentlawyer.ca is the email. It's 1-855-821-5900. You want to get a hold of Lior anytime. Member of the team, you can do that as well. And also employmenthourtv.ca is a place to go. You want to find out where you can catch our radio show. For the past half decade, we've been all over the radio doing this show, similar stuff. You want to catch it, go to that website to find a station that you can tune into. We also take a ton of phone calls on the radio show every week. We like to play a few of them on the air and get some feedback, get your thoughts on it. Well, your thoughts on it. So we'll have you listen in on one of those.
I was recently dismissed from my job. I'm in construction a year. I'm 40. I don't know what my rights are. I haven't seen the record of employment, so I don't know what it says as to why they dismissed me. I've been missing a lot of work due to an illness, and they know this, and it's been documented. I'm thinking that that's why they've opted to give me my walking papers.
Yeah, there's a lot to unpack here. So first of all, let's start with the fact that he was in construction. A lot of people believe incorrectly that if you're in construction, you don't get severance. That's wrong. You get the same severance as other employees. So let's be very clear. Construction means you still get severance if you lose your job. The only way they can let him go without severance is if he did something so bad, so terrible, that makes it impossible to continue employing him. Clearly, if he did that, he would be aware of it. So obviously that's not the case. And he says he was let go because of a medical condition. If in fact that is the case, again, as I said before, it's a human rights violation. You cannot let someone go because of a medical condition. It's illegal. It's as simple as that. And beyond that, even if we put medical condition aside, of course he's owed severance. So how much severance he's owed? Well, he's been there for a year, he's in construction. What I've done is I've taken that information, I plugged it into the severance calculator just to show everyone how that works. We'll talk more about it later. So he's been there for a year, he's 40 years old. So someone in his situation would be owed around 3 months of pay. So some people may think, well, wait a second. I thought there's this whole concept of a year or a week per year of service. Wrong. No, 3 months for this person. You can do that yourself at severancepaycalculator.com. So human rights violation potentially here, and certainly he gets severance. So what I told him when he called us on the air, on the radio show, is to give me a call, and I'll be able to help him get that compensation.
You know, it's amazing, and the reason why they do the show, so many people have been and will continue to be in that situation, and they turtle. They don't do anything about it. Well, the big bad employer must be right. You know, they know better than I do, but no, they got to make that phone call.
And you know, John, there's two reasons really why sometimes employers don't comply with their legal obligations. In some situations, the employer itself may not be aware of its obligation. They don't know, potentially. In other situations, the employer may count on the employee not knowing. But you cannot and should not assume that your employer is doing the right thing. It's your job as the employee to ensure that your legal rights are being enforced. And if you don't know what those rights are, if you don't know what you're entitled to, just call me.
Again, 1-855-821-5900 anytime is the number to get a hold of Lior at the firm. You know, every week we like to throw a topic out there and go through a bunch of bullet points to have you expand on. I think this week we're going to do, you know, no severance rules are not different for you if ... And it kind of spoke to what you mentioned about construction. So I'll get to one. You can expand on it. They're not different for you if you're in a federally regulated industry like banking, telecommunications, stuff like that, right?
Well, John, when I talk about severance, oftentimes people come to me and say, well, I know you said severance and what people are owed, but it doesn't apply to me. I'm in a different situation. Right. And almost always, it's not in a different situation. The rules apply across the board. And one of the most common things that people say, well, it doesn't apply to me because I'm in a federally regulated industry. As you said, banking, telecommunications, etc. And think, well, no, different rules apply. Well, let's make it clear. Your full termination entitlements are the same, whether you're in a federally or provincially regulated industry. They're the same, and they're based on your age, position, and length of employment. So whether you lost a job, if you're federally regulated, you work for a bank, does not mean you get less severance. You get the same severance. So don't believe any of those misconceptions. Call me if you lost your job. Go to severancepaycalculator.com. You don't get less severance.
Severance rules are not different if you are, as we just mentioned, employed in the construction industry. Now, this I think you'll expand on. I know we touched on it before, but I think a lot of people, it's a misconception of seasonal work might have something to do with that as well, right?
Yeah, and there's a lot of things that go on to try to essentially confuse people. Right. So a lot of people think, well, it's a seasonal job, then maybe I don't get severance. Well, if you're legitimately working in a seasonal job and you're not working off season, you're not going to get severance if you're hired on a seasonal job. But your employer can't decide midway through employment and now you're seasonal. You always work year round, now we're going to make you seasonal. No, that's a termination. The other thing is, and when it comes to construction, one of the reasons people believe that construction employees are treated differently is because your minimum entitlements are going to be different if you're in construction. But your full entitlements, we also call those common law entitlements, are exactly the same. So again, age, position, length of employment, so no, there's no different severance rules for you if you're in constructions. The same standard rules apply.
You know, I had a colleague come up to me just 2 weeks ago who was let go, and I said, you know, make sure you call Lior and pursue your severance options. What you should get, he goes, I would. He goes, but I'm part-time, so I don't think they apply. That's the next one on the list if you're a part-time employee. And I just put a big red flag up and said, no, wrong.
Exactly, because we've talked about this before, so you know. So let's make it very clear for those out there that may be working part-time and may not understand. You get the same severance if you're part-time. It's not different. Part-time, full-time, you get severance. Now, your severance is always calculated based on your compensation, on your salary. So if you're making $15,000 a year because you're working part-time, well, it's going to be calculated on the $15,000. But in terms of the months or years of severance that you get, it's going to be the same. So don't assume ever that just because you're part-time you don't get severance. The severance calculator, by the way, works for everyone. So part-time employees get severance.
So you have two people, one's a full-timer, one's a part-timer. He works half as many hours, same company. He makes twice as much money. But as far as length of time is concerned, they've both been there for 20 years. They're both going to get severance based on 20 years.
The dollar value will be higher for the full-time employee, but in terms of the number of months of compensation is going to be exactly the same for the full-time employee and the part-time employee.
Email us help@employmentlawyer.ca. We're talking about rules that are different or not different for you when it comes to severance. And the next one on the list is you're misclassified. We love this one as an independent contractor.
We love this one, but it's such a big issue. And it's probably one of the biggest issues, the biggest problems, and the biggest surprises that people have when they learn that what you call yourself does not matter. You can think you're an independent contractor, and you're probably still an employee. I don't get to decide. You don't get to decide. No one gets to decide if you're an employee or contractor. The law decides. So if you look like an employee and act like an employee, you're an employee. If you have a regular job, you work for a company for a period of time, you're going to be an employee, and that's very important when it comes to severance. Because if the law considers you to be an employee, irrespective of what you put on a piece of paper, you get severance. And of course, there's this middle category, John. You may actually not be an employee and still be entitled to severance because we have a category called a dependent contractor. A dependent contractor is someone that's not quite an employee, but does enough work for a company that they are still owed severance if the company lets them go. So bottom line, I'll make it very clear. If you lost your job, whether you're an employee, believe you're an independent contractor, something in between, call me because chances are, yeah, you're owed severance.
What are some of the things that someone who thinks they're an independent contractor is making them believe so?
Well, usually it's very simple. It's like, look at the piece of paper. I signed a piece of paper saying I'm an independent contractor. Or the company doesn't withhold my taxes. I pay my own taxes, so that makes me an independent contractor. It does not. It doesn't matter who pays your taxes. It matters whether you have a regular job, who you take instructions from, how long have you been doing it. Again, if you really have a job, you're not a self-made or a business person, you just have a job, then you're an employee and you get severance.
No severance rules are not different for you if you're misclassified as an independent contractor. And finally, you're employed by a small business owner with a payroll under $2.5 million.
Another big misconception is that people that work for small companies, people with small payrolls or companies with small payrolls don't have to pay severance or not the same amount. Wrong. The size of the payroll has nothing to do with your full or common law termination entitlements. They're the same. Again, they're based on age, position, and length of employment, not the company's payroll. So I've spoken with dozens, if not hundreds of people over the years that were convinced that they're not getting severance or they should not be getting severance because they work for a small company. Wrong. That's absolutely wrong. You can get as much as 2 years of severance, as much as 2 years pay. Doesn't matter if you work with a company that has one employee, the same rules apply.
We're going to talk about the Severance Pay Calculator, which we alluded to and went through a couple times, but in more detail as well. The new boss is not the same as the old boss when it comes to changing your employment contract. That is all coming up here, Employment Hour in 30. Stick around.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. John Scholes, Lior Samfiru, talking about your workplace rights, your severance, everything under that umbrella. We're the place you spend 8 hours a day, probably for 25, 30 years, so it's an important show. So we continue to inform and enlighten. We mentioned this a couple times before the break. We've used it. We'll run through it, called SeverancePayCalculator.com. Tell me about it.
SeverancePayCalculator.com. It's a tool that I created. It's a tool that I created because of all these misconceptions that are available, that are out there about your severance. And I thought about it. You know, when do people need money the most? Well, they need money the most when they have financial obligations, but they've lost their job. Because, you know, your creditors, your banks, your college education that you have to pay, those obligations don't go away just because you lost your job. So people were accepting inadequate severance, and they were doing that because they didn't know any better. So I created SeverancePayCalculator.com. Again, SeverancePayCalculator.com. It allows anyone to find out exactly how much they're owed if they lost their job. It's easy to use, it's free, it's anonymous, there's no strings attached, it's there for your information. You go to SeverancePayCalculator.com, you answer 3 questions and find out exactly how much you're owed, whether it's 2 months of severance, 24 months of severance, or anything in between. And you don't have to have lost your job to use it.
Sure.
Maybe you're curious and you want to know, hey, I want to be prepared. Or you think they're about to let you go and you want to have that information. You go to SeverancePayCalculator.com, and I know there's people watching us right now thinking, why do I need that? Because I know what severance is. Yeah. It's a week's pay per year of service, or maybe it's 2 weeks pay per year of service. It's not. Trust me when I tell you, you'll be surprised. So if you think that I created a tool that tells you what you already know, try it. Go to SeverancePayCalculator.com right now, see what happens, find out what that information is, and be armed with the knowledge that if you lose your job, now you know what you're owed.
Again, you can walk away anonymous, or there's a contact button at the bottom. We'll put you in touch with Lior and the firm. And if you're an employer, there's also an employer mode, which is handy as well. If you're thinking about letting someone go, you got to know, what do I owe them? What am I responsible for? It'll work for that too.
Works
right?
Just the same, employers and employees.
We'll run through a quick example here, the calculator. I'll let you expand on this one. It says, after 13 years at the same company, Annika worked her way up to HR manager. When a new VP stepped into the workplace, Annika was fired just 2 weeks later. The VP said that she didn't align with the company's new direction. Annika was handed 11 weeks of severance pay. Was she owed any more than that?
So a lot of people are going to say that, listen to this and say that's unfair.
Right.
You know, she worked there for all these years. Why should she be let go that way?
Nasty.
It's nasty. It's not fair, and I tend to agree with that. But from a legal standpoint, she can be let go as long as severance is paid. An employer generally can let you go for any reason as long as you get paid severance. So in this case, the question is, what is appropriate severance for her? Now, she got 11 weeks pay after 13 years of service. That is not even close, John. So I can tell you how much she's owed, but let's put that information into the severance calculator at SeverancePayCalculator.com so that if she was home and trying it, she could find out exactly what she's owed. So she's a middle manager, HR manager, 13 years of service. She is 38 years old as an example, and she was offered 11 weeks. Well, Severance Calculator says 15 months is what she's owed. Not weeks, months. 15 months. Now, for her, depending on that compensation, that could be a difference of 6 figures, John, depending on her compensation. So again, 15 months instead of 11 weeks. That's extremely important to understand that this is a common situation. We didn't pick this because there's anything unique about this. We picked this because what you're looking at there, what you've just heard us talk about, is a very common situation I see every day. So don't let that happen to you. Don't let anyone tell you that you're owed less than what you're owed. Use the severance calculator. Call me if you're not sure, and make sure you have the right information always available to you.
You know, 11 weeks to 15 months, that's 15, 20 cents on the dollar. That's crazy.
That's
you walked away
nothing. Yeah, and then, you know, if you're making $80,000 a year, that could be literally a difference, potentially of close to $100,000. And that's, again, I'm saying this because this is a very common situation.
1-855-821-5900 is the number to get a hold of Lior. You can go to employmenthourtv.ca as well. While you're there, you want to check out where you can find the radio show, the weekly radio show we do every week and have been for years. We take a ton of phone calls. People call in. They have questions, probably like you have right now. So let's get to a call, and you can comment on it.
I've been working for a company for a while. When I was hired, we came to a few agreements, for example, taking a vehicle home and what my start time would be and when I would start to get paid from, right? My old boss, he's been fired, so now the new one is changing some of those arrangements, but obviously they're not changing them to my benefit, right? Do I have to accept that? Is there something else I can do?
Yeah, no, and it's not uncommon when a new boss comes in that they decide to change the deal, change the terms of employment. They want to put their own impression on the workplace. Sure. But you can't actually do that. You can't change someone's terms of employment. So in this case, if he works and has certain terms, a car, etc., and the company says, we've decided to change this. You're not going to have a car. You're not going to have the other perks that you had. Well, wait a second. That is a big deal. So he may have the right to treat that as a constructive dismissal. A company does not have the right to change the terms of employment in a significant way. And if they do, it gives the employee an option. The option is to accept it. Fine, you can accept. Or you can say, no, I am not going to accept this. I'm going to treat that as a termination and get my severance. It's as if the company lets you go completely on their own. The thing is this, if you're going to accept the change, the problem with accepting is you've essentially opened the door and you've given them the right potentially to do it again. So today it's just your car that's been taken, but because now there's this precedent, next time it could be something else. And then they can touch your compensation. So my concern is if you're going to allow the company to change the terms of employment and you let them get away with it, the next time they do it, you may not be able to do anything about it. So you have to act now. So what I say in this situation, call me. Let's talk about constructive dismissal. Let's talk about whether it makes sense to accept or leave with severance. We'll talk about how much severance you're owed and how to go about getting it.
Can you slide in between? Can you say, you know what, I don't know if this is really going to work for me. I'd like to take it out for a spin for a week or two and see if it works. And then if I don't like it, I'm not doing it.
Well, certainly if the change is not obvious. For example, if they change your commission structure and you want to see how that's going to impact you, you can tell the company, I'm going to try it out, see how that impacts me. But if the company, let's say, takes your car, well, you kind of know what that is. You know how that's going to impact you, so you may not have an opportunity to really try it out. But in some situations, you can try the change as long as you tell the company, that's what I'm doing. I'm not accepting it. I'm just going to try it, and then we'll see if I can actually do it.
Reacting to a performance improvement plan. We'll get to that. More of the phone calls from our Employment Hour radio show here coming up after a short break. Stick around.
Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact. The labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
Welcome back to Employment Hour in 30. 1-855-821-5900 is the number anytime to get a hold of Lior, member of the team. And we also have help at employmentlawyer.ca. That is email. We do a ton of radio shows during the week. You want to go to employmenthourtv.ca to find a station near you where you can tune into the radio show. A lot of questions come through. We take the phone calls and we'll play one back, and I'll get you to comment on it, pal.
45 years with the same company. I'm a bank teller, and those jobs are disappearing because of digitalization of people's banking services. I'm over 60, and I have the feeling that I'm kind of going to be going through that. I had asked upper management if they would package out a part-time employee, and they said, well, we don't offer packages to part-timers. That calculator, is that applicable to part-time employees as well as full-time?
I remember that phone call. It's a good one.
It is a great one. I remember as well. And so let's make it very clear. If you lose your job, you're owed severance. Doesn't matter if you're full-time, doesn't matter if you're part-time, doesn't matter if you're young or old or senior position or not so senior a position. You get severance. And there's absolutely no way for a company to let someone go, in this case, 45 years. That's ridiculous to suggest no severance. But even if it was 4.5 months, she would still be owed severance, even if she's part-time. So what I say to her is, if they're changing the terms of your employment, maybe it's a constructive dismissal. Otherwise, you have the security of knowing that if they decide to part ways with you, you're going to get severance. In fact, you're going to get quite a bit of severance. How much? Well, again, how could she find out on her own how much severance? She could go to SeverancePayCalculator.com. So I've taken that and I plugged it in just to show our viewers as to what that would look like. So we know she's a bank teller, John. She's there for 45 years. My gosh, it's a long time. In her 60s, well, the severance that she'd be owed would be right around 24 months. It could be as little as 18 potentially, but as much as 24 months of pay. So that's probably what I would assess her being owed, 24 months of pay. So we go from a situation where she's told, you don't get severance, you're a part-time employee, to actually being owed 2 years pay. Wow. Don't ever believe anything other than that. If you want to know if you're owed severance, you ask yourself one question: did I lose my job? If you did, you get it.
Again, severancepaycalculator.com. You'll want to find out what that metric, that math would be. It's as simple as that. Go there, 1-855-821-5900 to get a hold of Lior. Got a ton of emails. You get a ton of questions at the firm. People throw question scenarios at you all the time. We printed a couple off, and this one I found really interesting. I want to run it by you. Angelo's employer is threatening to fire him for cause if he doesn't improve his sales performance. They want him to complete a performance improvement plan. Angelo feels that his sales are down because the company's prices aren't competitive. What does he do?
Yeah, it's the old scenario of, we're going to make your life harder and make it more difficult for you to do your job, and then complain when you can't do your job. So yeah, and this is very common with salespeople, because as a salesperson, you can only control so much. You can't really control the pricing. You can't really control the quality of the product. So if the company doesn't allow you to do your job, your sales are going to go down. So if Angelo in this situation, if the pricing increases and he can't sell as much, well, it's not his fault. And if the company wants him to sell more, they have to provide him with that help. So it's not enough for the company to say your performance is not good enough. The company should take a hard look at itself and say, what can we do to help you improve your performance? So if they put him on a performance improvement plan saying you're not selling enough, well, wait a second. There's a reason why he's not selling enough, and that's because what the company did with the pricing. So what I want him to do is I want him to tell the company, and I want him to put that position in writing so that they know he's not agreeing that he's not selling enough. Tell them the reason. Make sure that they know that the reason I'm not selling enough is I'm getting feedback from the customers that the prices are too high, for example, so I can only sell so much. The problem with being silent and quiet is then you're considered to have accepted it. Yeah. If you don't say anything, the company puts you on a performance improvement plan and you just accept it, the law is going to say, well, wait a second. You accepted it, so how can you complain about it later saying that wasn't right? That makes it potentially more difficult for a company, or more easy for a company to let you go. If you want to make it more difficult for a company to let you go, certainly to let you go for cause, put your position in writing. If you disagree with the performance improvement plan or with the performance review, say so. Put that in writing. Don't make it easier for the company to let you go.
Got a couple minutes left. Another resource for you to ask questions, terminationquestions.com. I'll run through a quick scenario here and you can answer before we wrap for the morning. It says, I've been working at a company for 20 years as a manager, and now they're telling me that I'll be laid off, but only temporarily. They say I'll be called back later this year, which is something they can do according to the Employment Standards Act. Is that true?
Well, it's true that the Employment Standards Act says that they can lay you off temporarily, but the way that's been interpreted by our courts is no, you actually cannot be laid off temporarily unless you signed an employment agreement that gives you that power, or gives the company the power to lay you off. So in most cases, John, a temporary layoff is not allowed. A temporary layoff is a termination, which means you get severance. So no, you don't have to sit at home for months not getting paid, hoping that they call you back. You can tell your employer, I don't accept this, and then the employer has to pay severance right away. That's very important to understand. The other issue with accepting the layoff and sitting at home, and you know where I'm going with this, is that you've given them the right to do it again. And then you come back and they lay you off again. At that point, you can't do anything about it because you let them do it the first time. So remember, with a temporary layoff, it is a termination. It is something a company is not allowed to do. So you shouldn't be just sitting and letting them do it. It's a very dangerous thing to do, John.
You really should take a step back before you accept it and think about what the ramifications are going forward, right?
And you may not know what the ramifications are, which is why I make it so easy to reach out to me. Let me talk to you. Don't make any decisions about your job, about your workplace rights without getting some proper legal advice.
A lot of information every morning here on the weekend. You want to catch more. Next weekend we'll be back doing the show as well. Some contact for you just as we wrap it up. Email is help@employmentlawyer.ca. There's also employmenthourtv.ca. While you're there, you can see old shows. You can also find out where and when you can catch the radio show, Employment Hour, as well as severancepaycalculator.com. Find exactly what your severance offer should be. The number is true, the number is accurate, the calculator works, and over 500,000 people have used this. And like you said, they're shocked and surprised and delighted when they find out exactly how much severance they're actually owed. And of course, a phone call, 1-855-821-5900, anytime to get a hold of Lior. So that's the information you got, right?
Let's do it again next time.
Appreciate it. We'll catch you next time.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.